Any information in the video about the companies or services mentioned is intended for educational purposes only. This YouTube channel and its owner are not responsible for the results experienced by viewers. The first video explained a 10-step process to convert an idea into an electronic device prototype. This video explains the first step, idea and brainstorming. The first step in the 10-step process of making a new electronic device is taking the initial idea and brainstorming many angles of it to adjust and improve the original invention. You have this brilliant idea and are excited to share it with others. However, keeping it to yourself is important until you protect your invention. There is a legal process for protecting your intellectual property, and it is called a patent. You don't have to have a fully functional prototype of your idea to receive a patent. However, you need to adequately describe your invention in a way others would be able to build and use it. Once you patented your idea, you could potentially sell the idea to someone else or a company. That is called licensing an idea. But this series of videos illustrates taking a new concept and working through the process of making it a unique and valuable product. Patenting the idea involves a few steps. Not all of the steps we'll learn about are mandatory. Your idea must meet 2 criteria to receive a patent. It should be novel and useful. To make sure your idea is novel, you need to search whether someone else has already dreamed it up and holds a patent or not. We're not talking about a quick Google search. You must conduct a patent search. Consider this if someone already has your idea before. That inventor patented it, but they never made the final product to take to market. So with the Google search, you cannot find out if it exists or not. That's a common reason you haven't seen a very cool idea become available for people to buy and use. Here, this site, uspto.gov, the United States Patent and Trademark Office, or on patents.google.com, that you can search your idea. Keep in mind, searching for an idea is not straightforward. You don't pop in a few keywords and you're done. Many parameters and criteria are involved in searching for an idea that may be patented. For a small fee, companies like thoughtstopaper.com will conduct the search for you using their own experience and expertise. Let's say the result back and in a search report you found out some other person came up with a similar idea before you. Don't worry, it is very common that you get different ideas like yours in a search report. Beware that maybe even more similar ideas still exist that is not come up in your search report. This is where brainstorming is so valuable. Brainstorming produces new ideas and solutions to problems. So, the idea and invention are studied and discussed to develop a particular feature that makes your idea entirely different from other existing or potential products. The best way to brainstorm is to do it with other people. But before you do, protect your idea by asking all involved to sign a non-disclosure agreement or NDA. It's very common, and no one should take exception to being asked to keep your work confidential. The NDA is a contract between you and the people in your brainstorming group. Companies such as Nolo can create an effective NDA for you for a small fee. So, now you shaped your idea in a way that is not similar to the other idea, at least the ones that showed up in your search report. The next step is to start the patent application. There are 2 types of patents application here in the United States, a utility patent and a design patent. A utility patent is for products with novel functionality or use. A design patent is granted to the physical shape and dimensions of a product. For instance, the first Apple smartphone's dimensions and shape received a design patent for the unique way it looked compared to any other mobile phone. Its iCalendar functionality received a utility patent for its novel functionality. Drilling down a bit further, there are 2 methods for utility patents, a provisional patent or non-provisional patent. Non-provisional or regular patent is the process that starts when you reveal your idea to the U.S. Patent and Trademark Office, and the examiner begins the review. This is a very long and expensive process. The average time for non-provisional patent pendency is around 28 months and something in range of $4,000 to $20,000. The non-provisional patent is generally granted for 20 years from the date the patent application is filed. However, periodic fees are required to maintain the enforceability of the patent. There is another way. The provisional patent, it's cheaper and it's granted immediately. An invention receiving a provisional patent doesn't undergo examination at the USPTO, and it is only valid for 1 year. Think of a provisional patent as a placeholder. It's not a fully binding patent. Instead, it can show to the court who was the first one to register it. It's very useful when you want to market your idea, and so you need to share it with others. A provisional patent gives you the ability to market your idea or even license it within a year. After that 1 year, if your invention is profitable, you should invest in getting a non-provisional patent. Just remember, after 1 year, the provisional patent must be turned into a regular patent. Otherwise, it becomes part of the public domain. So, it's basically up for grabs and can't be patented because at that point, it's no longer something novel. A provisional patent also gives you a year for testing and getting feedback from potential customers to improve it. NDAs and patents are not ironclad protection against someone grabbing your idea for your invention and trying to run with it themselves. The value of having formal documentation is that you have the evidence you need to prove in court it's your original invention, and it depends on your lawyer's skills to make you a winner if you are an original inventor. If you like to know more about patenting and licensing ideas, I recommend reading the Sell Your Ideas With or Without a Patent by Stephen Key. In the next video, I will elaborate on how to create a comprehensive specification for an electronic device. Please subscribe to our channel so you won't miss any of our upcoming videos. Please leave us some feedback down in the comment section. We're also looking to improve what we have to offer. Thank you, and please stay tuned for more.